Okay, welcome everyone. Thanks for joining today's webinar, the DOJ's new agenda, what every business should know about the False Claims Act. I'm excited to introduce our speaker, Evan Gotlob. He's chair of our White Collar Crime and Government Investigations Group and a leading voice on corporate compliance. Today, Evan will explain what the False Claims Act means for businesses, why the DOJ's new focus matters, and share practical steps to help reduce your company's risk. We'll wrap up with a question and answer, so feel free to submit questions in the question and answer box. And Evan, the floor is yours.
Thanks, Julia. And just so everyone knows, we're going to share the presentation afterwards, so don't worry about taking notes on it or writing anything down. You'll have it all afterwards. But thanks for being here today. I appreciate it. We're going to talk about the False Claims Act a little bit. This administration's been very active in False Claims Act prosecution and in their memos about the False Claims Act. So let's get started and just talk about a little bit about what the False Claims Act is about. Give me a second to get my slides going. All right, so basic overview of the False Claims Act. Sorry, let's go back. Um, the False Claims Act is a federal law that imposes liability on individuals who basically steal from the government. And the only way these come about is if these organizations, individual organizations, large corporations get federal money and somehow defraud the government. And the primary purpose is to save the government money. The reason why this is so popular under the current administration, as many of you may know, Elon Musk formed a group of individuals that were looking for government fraud and waste. And the False Claims Act is probably one of the most significant laws that the government can use to get back this money that they're basically stolen from. But they don't really do it on their own. So let's talk about the False Claims Act a little bit. Some of the key provisions of the False Claims Act: liability. How does it work? Just as I said before, it makes an individual or corporation liable if they defraud the government, by false records, false claims, etc. Now, the key tam provision is interesting because it allows private individuals to bring whistleblower claims. And this just doesn't mean private individuals on their own, but for example, and if an individual works for a large company like JP Morgan, and JP Morgan's stealing, millions and millions of dollars from the government. I'm not saying they are, I'm just using an example just so everyone knows. That individual can bring that claim through an attorney. They could file a claim under seal in federal court and get a large settlement later on, upwards of 35%. So, for example, if there's a $20 million fraudulent claim and it's brought by an individual, a key tam, which is called a relator or whistleblower, that individual can get upwards of, $6 to $7 million of that claim. Obviously, if they have a lawyer, they'd have to pay some legal fees, but they don't have to pay anything up front. So it's very advantageous for when individuals see fraud in their organizations or even organizations they know to bring it to the attention of a lawyer or the federal government. It could be very financially beneficial to both the federal government and to the individuals. Now, what are the penalties like? Well, we just talked about it in the millions, but if the fraud is as low as maybe a couple 100,000, there's something called treble damages. And what treble damages means is the damages are multiplied by 3. So if an individual or corporation brings a False Claims Act claim against another defendant, they can get as much as 3 times that amount. So if the claim was $100,000, they could get as much as $300,000, therefore increasing their financial benefit in the end. So how do False Claims Act claims work? You can hire an attorney and file one under seal with the federal district court in the area where the action took place. Like, for example, I'm speaking from Rhode Island right now. So if I want to file a False Claims Act claim that took place in Rhode Island, I would file it in federal district court in Rhode Island, right down the block from DarrowEverett's Rhode Island office. And then that'll be filed under seal. And the reason why it's filed under seal is because you want to protect the whistleblower or the relator we spoke about before. Now, what happens next? Usually what happens next is the federal government will get a notification about it or they'll know about it and they could jump onto the case. And what that means is, like, the U.S. attorney's offices, there's 93 of them around the country, can join the case. And if they join the case, they basically take over the case. So if you're working with a law firm or a group of lawyers, you want to kind of control the narrative before it goes to DOJ. And what that means is You want to really make your claim as solid as can be and get all the work done before the DOJ takes it over because you're not going to really be that involved with the case moving forward. It doesn't mean you're not going to get the settlement because you will. You're still the whistleblower that brought the claim to forward, but you're not going to really have control of the case, or your lawyer really won't have control of the case. But it's very beneficial for the Department of Justice to jump onto the case because it gives a lot more, oomph, power of the claim, and therefore a settlement kind of happens really quickly. During my, 10 years at DOJ, I did a bunch of False Claims Act claims, and once we decided to get involved on the criminal or civil side, settlements happen within 6 months. So it's very beneficial to the relator and to the attorney on the other side to bring the case towards DOJ. Now, the basic elements of the False Claims Act, they're pretty straightforward. Um, the claim must be false or fraudulent. Obviously, that speaks for itself. The defendant, so the accused party, the organization, the individual, whoever, they must have knowingly acted to defraud. Sometimes things happen by accident, but usually when you have like multi-million-dollar fraud cases, it's an intentional act to defraud the government. The claim must have, materiality claim must have materially influenced the government's decision to pay a claim. If the government's paying something like Medicare or Medicaid, it's clearly a material claim. Um, Causation, the False Claims Act claim must have caused the government to um, pay with a certain amount of money. Like a lot of these False Claims Act claims come in the healthcare industry, but as you'll see later on in the presentation, it's approaching other industries as well. So it's good to be aware of this. Um, Reverse False Claims Act claims happen. They're few and far between, but I wanted to let you guys know because they do happen. Is when an individual is like defrauding the government without causing the government to pay them anything. It's kind of a reverse kind of fraud. So you don't really need to be that aware of that one, but it's something that does happen on occasion. So this is really important because a lot of times False Claims Act claims don't come to fruition for years and years and years. Now, in a typical False Claims Act claim, it has to be brought in within 6 years of the action. So that means if we were talking about today, like July of 2019 would be the latest it can be. But during my time at DOJ, I was involved in cases that were more than 10 years of fraudulent claims ago. And now, how does that work? That's why the second bullet is really important. When should the government become known of this? So if a whistleblower brings that claim and it's public, it goes 3 years from that date. So we're talking 2022 now. Now, a lot of people think like, well, the fraud happened over years and years and years. How does that affect it? It's really when the last fraudulent act took place, and nice for when you're on the plaintiff side, if you're the individual bringing the claim, nice for them is a lot of those claims like don't come to the light of day until much, much later on. So you have 3 years from that date. So it makes it a little easier. Now, if you're an organization and wanting to defend those claims, it makes it a little more difficult because a lot of times these fraudulent actions are taken in secret. So the statute of limitations really doesn't play a role if that's the case. But I just wanted everyone to be aware of when these claims can and cannot be brought. But there have been claims, during my time that I've been involved in or not been involved in that started 15 years before. So that 6 years statute of limitations is not really ironclad because of the provision that allows you to bring a claim up to 3 years after when it should have been realized. And that's a very subjective should have been. So it's really at the purview of the courts when the defending party files a motion to dismiss. Now let's talk about whistleblowers. Whistleblowers are the individuals that bring the claim. A lot of time, whistleblowers are disgruntled former employees of organizations that they're bringing the claim against. They're insiders who still work at the organization, and they're in it to stop the fraud and to get paid. Like it's as simple as that. Now, how do they get paid? Well, as we spoke about earlier on, they get up to 35% of the settlement. So if the government or if the individual attorney that's representing the whistleblower decides to settle for, let's say, 10 or so million dollars, the whistleblower can get $3.5 million. Obviously, they're going to have to pay attorney's fees, and usually the attorneys take about a third of that. But you're still talking to 20 to 25% of the claim. And there's been some claims in DOJ, over the years that have been billions of dollars. So just think of how much the whistleblower benefits from that. And the whistleblower's name is pretty much kept private the whole time. I worked a couple of different cases at DOJ where the opposing side never knew who the whistleblower was, and we got multi-million-dollar claims. The job of the attorney who's representing the whistleblower and the attorney and the prosecutors from DOJ is to keep the whistleblower's name secret so they don't blow their case, they don't risk the safety of the whistleblower. So that's something to know about this case. And when DOJ jumps on at the end, usually they come towards the end of the case. So the whistleblower is really not involved at that point, besides in the negotiation of the settlement. Now, how do they start? Well, there's actually a false claim. Somebody committed fraud, right? That organization made a false certification to the government. They were paid something by the government that was false. I'm going to give you an example of something that people may not think of. We spoke about healthcare a lot, but I prosecuted an organization that did buildings for the government. Like their job was coming up with um, engineering plans for government buildings and executing those plans. Now, a lot of individuals may not think that that's a company that's subject to the False Claims Act, but they were paid by the government. So if they were paid by the government for anything, they could be subject to the False Claims Act. And what they were doing was they were submitting false hours over and over again for about 2 years. They fired an individual who became a relator. This relator filed the false claim in federal district court. They brought that claim to us, to me and my colleague in the U.S. Attorney's Office, and we prosecuted the organization both civilly and criminally. We forced the organization to close down, and we got a $4 million settlement where the relator ended up, walking home with about $900,000 and basically did nothing. The relator told us about the case, met with us 2 times, but over a 2 to 3 year investigation, the relator was not involved and ended up in a pretty good place. Now, over the years, DOJ, I don't know, some of you may know about these memorandums or not. They happen in all areas of law: drug cases, white collar cases, violent crime cases, higher education cases. There's been a couple of memos over the years, but most of the memos have all been at either during the first Trump administration or the second Trump administration. During the first Trump administration, the Sessions memorandum protected organizations against the filing of the False Claims Act and said just because an organization isn't in compliance with the government, they're not subject to the False Claims Act. That's kind of changed a little bit over the years. In 2018, only a year later, the chief of the civil division in Main Justice in DC created a list of factors that you had to meet to bring a False Claims Act claim. The merit of the claim, if they were duplicitous with other claims in the past 15 to 20 years, if they were interfering with ongoing information or investigation that the government was already doing. And then they weigh the burden of the claim against the government and against the individual that's filing it. And it really minimized the amount of claims that we could do during my time at the Department of Justice. But things changed in 2025. When DOJ was created by President Trump and Elon Musk, the False Claims Act cases came to the forefront of what the government wanted to do. Now, what is the current administration looking at? Because that's most relevant to people bringing whistleblower claims and also organizations defending them. Like, what are they looking at? Number one, they're always going to look at healthcare and COVID relief fraud. There was a lot of fraud with the PPP loans that started early in the Biden administration, 2020, and that's still going on. So if an organization is getting money from the government, they still are. They're still getting this COVID money, which is crazy to think about. If they're taking it fraudulently, they're subject to the False Claims Act. And as late as last year, and even though this was under the Biden administration, the Trump administration has continued this, they have provided enhanced support for whistleblowers. There's a whistleblower program now that supports whistleblowers, that gives them financial support and supports these false claims going forward. DOJ has gotten a little more tech savvy, and they're starting to use different data analytics to bring the False Claims Act cases themselves. They don't really have the manpower to bring it themselves as much as the individual whistleblowers. So the whistleblowers will still be a significant part of the False Claims Act. DOJ is just trying to ramp up, in the AI era with their data analytics, mostly in Main Justice. There was a memo earlier this year that DOJ wanted to do some interagency collaboration. They are assigning one person in every U.S. Attorney's Office to be like their False Claims Act person, even though there's units in the larger offices to work with different agencies like Health and Human Services, Department of Education, Department of Energy, Department of Education, and other organizations to work and make these cases bigger and bigger so the government can recover the money that they fraudulently gave out in the first place. The reason for these memos that the Trump administration is doing is to deter actors. It may deter actors a little bit, but they're still going to be there going forward. So it's good to be in compliance with the False Claims Act. Now, who's subject to this? Well, basically any organization that receives a dollar. And what should these organizations do? Like, how do they comply with this stuff? Well, if you have a DEI program, you should look into it and make sure that it's following all the proper federal guidelines. Because as individuals know, if you've observed the press briefings over the last couple months, the Trump administration is really going after DEI, specifically in college universities. Look at Title IX. Title IX is something that really just affects higher education institutions. And if it's unlawfully favoring one side or another, the Trump administration doesn't like that. Also, civil rights policy, similar to the other two, that's something that the administration is looking at as well. Now, what's the best thing an organization can do to prevent that? You could create internal compliance committees, individuals that look into basically the area of the organization using federal money. You don't need to look at the whole organization. Just look at what areas are getting federal money and how that money is being used to make sure you're in compliance. And if you're not in compliance, fix it. If it's fixed before the government gets involved, even though it might be a past, malfeasance or fraud, usually the government's going to go pretty soft on those organizations if they proactively change their tune. Basically, as the Trump administration has forced different universities to change their DEI policies, they've backed off and continue to give them federal funding. So that's like an example of it. The best thing that these companies can do if they don't have legal experts on the inside is hire law firms like DarrowEverett or other firms that have experts in the area of the False Claims Act and these compliance issues, and create a compliance program that would prevent them from having millions in damages down the road. And a lot of people think that it's expensive to bring in lawyers from firms to figure this out, but it's a lot more expensive to deal with the claims on the back end, which could be millions and millions of dollars, and then multiplied by 3 with the treble damages. Now, some relevant case law. There's no law that's against the False Claims Act, but in 2023, federal courts, the circuit courts have ruled that scienter, which is the mindset of the individual who's committing the fraud, is subjective, not objective. So it's not a reasonable person standard. It's the mindset of that person that's committing the fraud. Now, in both 23 and 25, the Supreme Court, a couple of the justices, led by Justice Thomas, in dissenting opinions, have held that the False Claims Act qui tam provision is unconstitutional under Article 2. This is not a majority opinion. It was only two conservative justices that were against the False Claims Act, but it's something to keep an eye on going forward if more False Claims Act cases come to the forefront in the federal government. Now, just in wrapping up before we get some questions, the False Claims Act is a very effective tool used by the federal government to recover money. It's one of the most successful tools the government has used to recover money in the last decade. And as the Trump administration has said multiple times, they are trying to diminish fraud, and the Republican-controlled House and Senate agrees with that. So they're going to use the False Claims Act in any way they could. They've been targeting higher education institutions first, but that's not going to stop. They're going to go after big hospitals, smaller medical practice, et cetera, going forward. So the best thing that organizations could do is create a compliance program, speak to an outside expert to make sure they're in compliance with the False Claims Act. Because if they're not, if they're committing fraud, even the smallest level, they could suffer millions and millions of dollars of damages down the road. And if it's a smaller business, it could lead to the business closing. All right, that's what I got. I'd like to open it up to questions if anyone has any questions.
All right, let's see what we have for questions.
Yes, and once again, everyone, those in attendance, you can ask those questions by entering them in the Q&A box at the bottom of your screen.
All right, so first question we have is, how should businesses outside of traditional high-risk industries reassess their compliance programs given today's climate?
It's a really good question, because a lot of the high-risk industries are already doing that to an extent. I think what they need to do is they need to take a step back, see what funds they're receiving from the federal government, and look at overarching policies, whether it's with hiring, DEI is a big target of the government. So if there's a program there, and see like how how the organization is using their federal money and how the company is going into effect. And it could be a simple conversation between the head of HR and maybe the president of the company and come up with a compliance program. So there's a checks and balances where maybe monthly they'll take another look at where these federal dollars are going and what they're doing and how their internal policies are working. But you don't necessarily need to hire an attorney right off the bat. But if you're not comfortable, it's probably a good idea to hire somebody with experience because myself or some of my colleagues throughout the industry can give you a pretty quick presentation and come up with a plan pretty quickly once they look at the company's procedures and policies.
Great. The next question we have is what protections and incentives do whistleblowers have under the FCA, and how should companies factor that into compliance planning?
They have a lot of protections under the FCA. The biggest one is their names don't have to be public. So as much as defending large organizations want to know who the whistleblower is, they almost never need to be revealed unless this was something that could go to trial. And I'll tell you, I've never seen a False Claims Act trial in my career, over 15 plus years. So it's likely that the defending organizations would never find out who the individual is. So the privacy of not knowing who the whistleblower is a big deal. That's the biggest protection they have. Also, no settlement can be done by the federal government without sign off by the whistleblower. So even though, as I said earlier, the whistleblower is not that involved once DOJ adopts a case, they still have to sign off on the settlement. So for example, let's say DOJ agrees with the defending party about a settlement for $5 million, but the whistleblower only wants to settle for $7 million. A lot of instances, that settlement number goes up because of the whistleblower. Two of my cases went up because of the whistleblower, and the parties agreed because they knew that they were looking at a lot more damages, so it was easy to settle with the whistleblower. So the biggest protections for the whistleblowers are really anonymity and the financial benefit that they could receive down the road.
Next question is, besides the federal FCA, are there any analogous state statutes that relate to state funds?
Almost every state has a similar statute to the FCA. The damages aren't as high as the federal government, but if states give out money, they're not called the False Claims Act. In Rhode Island, it is, for example, but other states have different names. I don't know the name for every state, but state attorney generals can bring the cases. You can bring state whistleblower cases. So they're very similar in terms of how the cases work. They're just called something differently in a couple of states, but most states do have it and do enforce it and are very successful on a much smaller scale than the federal government because the federal government, in terms of behavior, can reach across state lines, but they do exist in all these 50 states. That's correct.
All right, we have a few more questions. How should companies respond if they receive a civil investigative demand or subpoena related to an FCA matter?
Well, if the companies don't have an expert in-house, like an expert attorney in-house, they should hire a lawyer to look into it. They shouldn't respond to the government without having a lawyer respond to it. And if they want to respond in a short amount of time, they should have their internal lawyer write a letter, say that they're in the process of hiring counsel. They'll respond in due time, usually within a couple weeks. Hire an attorney, have that attorney in their team who knows about this, look into the case, try to comply with the case before even responding to the Department of Justice or the government or the opposing party to make sure that they have all their ducks in a row before they respond because the damages level could just increase. So it's kind of really, really important to act quickly and to hire an expert to look into it and to make sure that they're safe before they speak to the government on those matters.
Next question. Have you seen any notable shifts in the DOJ's approach to whistleblower-initiated cases recently?
The healthcare industry has always had a lot of False Claims Act cases. That's not going to change. It's been the same for the last 15 years. The biggest shift has been on higher education institutions, the whole DEI Title IX initiative that this administration is really focused on. So that's the biggest shift I've seen. The whistleblower protections have increased. Prosecutors have been even better at hiding the names of whistleblowers and getting more damages for them. So on on the side for all organizations, that's the biggest change. But like really industry-wise, the biggest change has been an increased focus on higher education institutions. I would say is the biggest change that I've seen, and that's only been in the last 2 to 4 months.
All right, looks like we have two more questions. First one is anything you've seen in terms of cases going after nonprofit federal contractors on themes of FCA infractions?
Usually the nonprofits aren't targeted in these cases. A, because they don't have a lot of money to pay damages, and B, because they would probably just go bankrupt if these cases are brought. And a lot of the whistleblower cases come from the private institutions. There's been a few cases of like very small damage cases, more on the state level on nonprofit institutions, but the focus has still been more federally. So more on the larger, like bigger companies, but it's there. It just hasn't been a focus of prosecutors. A lot of times DOJ looks for the big fish, on these cases, and sometimes if there may be fraud involving a small not-for-profit institution, they won't adopt a case because to them it's not really worth their time in terms of the recovery amount.
All right. And then the One Big Beautiful Bill had a provision extending the 20% penalty for excessive refund claims to all employment taxes, including the Employee Retention Tax Credit. Could liability under FCA extend to situations where federal law already imposes a penalty?
I haven't looked into the details of all the whole big beautiful bill, but I don't think it's going to directly affect the False Claims Act cases. It's more on the tax side, so the penalty won't change on the FCA cases as of now. There hasn't been a specific law that's changed it in the big beautiful bill or anything not going forward, so it's pretty consistent with the 35%, with the treble damages on whatever the damages are. As I said earlier, there was cases as high as the billion, so there's no cap on damages. So I don't think the percentages have changed yet. They may change in the future, but not based on the big beautiful bill.
And it looks like we have another question. We've heard about an uptick of FCA cases related to noncompliance with cybersecurity requirements. Any thoughts on that?
Yeah, it's a tough field now with AI and everything like that. Cybersecurity is something that all companies need to look into, big, small, medium, whatever the size is. So I would say the best thing to do would be get a cybersecurity expert in or your IT experts and really make sure you're as secure as possible in compliance with government regulations to avoid any False Claims Act cases in the future. It is something the government's looking into. They're looking at for a variety of ways to recover damages or money that's taken from them fraudulently. So the best way is to try to like hit the compliance in the face before the government comes knocking on your door. And that's the best way to avoid it, but it's still pretty nuanced. So we really don't know how it's going to play out. But if the government could prove any sort of fraud because of lack of security or lack of cybersecurity, they will moving forward.
All right. If there are no more questions, that wraps up today's webinar. The presentation and the slides will be available. Well, the recording of the presentation and the slides will be available on our website within the next day or so. And that pretty much wraps it up.